My name is Bill Orth with the law offices of William S. Orth. Oftentimes I get called with the question, what do I do if I have a child with a person and we're not married and we no longer living together? That's what's commonly called a paternity action in the state of Florida. It's somewhat like a divorce, except you're not going to be dealing with the distribution of assets or liabilities. Distribution meaning splitting those assets and liabilities. Instead, you're going to be only talking about child support, time sharing, or what's commonly known as visitation, custody, or what's commonly known as where a child is going to live. Some of those legal terms we don't use in the state of Florida anymore, such as custody and visitation, but the concepts remain the same. Essentially, the first question that needs to be answered in a paternity action is, who's the father? In the state of Florida, we don't have a presumption of paternity unless two people are married, so that does need to be determined. Oftentimes the parties admit paternity, so we move on to the next question very quickly. You need a court order or a final judgment from the court which may entitle you to either receive or have to pay child support. You're also going to receive a final judgment which will entitle you to a specific amount of time that you're able to spend with that child. That court order may also specify where a child is to reside for school purposes, because we all know that it's important to establish residency, to establish where you can enroll your child into school. For more information on this topic, you can visit my website at www.williamorthlaw.com. You can call me directly at my office, 407-772-0000, or you can email me at worth@williamorthlaw.com.